So that's fairly easy enough to understand. If evidence isn't going to be reliable, then it makes sense to keep an eye on that and not want to bring it into a courtroom. If a confession is obtained under torture, then we say, well, we don't want to use that confession in a courtroom because it's not reliable. But we even exclude some evidence, even if we think it's reliable. There are cases where it's not that we don't think the evidence is true, we just decide that there's something about the way the evidence was obtained that we would like to discourage. We don't want people to do this. We don't want people to engage in this way of obtaining evidence. And so because of that, we have to say, well, the only way we're going to discourage people from going about getting evidence this way is by not allowing them to use it as evidence, right? And we saw this already earlier in the year when we were talking about Section 8, where even if the police have evidence that shows that somebody's guilty, if they breach Section 8 in the way of obtaining it, then a court might decide to not allow it in as evidence. This doesn't just apply to the police. It can also apply in civil cases involving private citizens, where the way that somebody got the evidence they want to use in a court case is enough that the court may want to exclude it on this basis. That can involve things like, depending on the jurisdiction in North America, there are different rules about whether or not it's okay to record people having a conversation when they don't know about it. In a lot of jurisdictions, as long as you're participating in the conversation, that what they call one-party consent, as long as you're participating in the conversation, it's considered legitimate for you to record it. But in some jurisdictions, there's not even that. But generally speaking, if you're not part of the conversation, it's unlikely that that will be something that's going to be admissible, because we want to discourage people from secretly recording other people's conversations, and we won't let them use it as evidence on that basis. The Civil Code of Quebec has an article that expressly points out that it's not just up to the two sides to decide, well, if I'm in a court case against somebody else, I can object to the evidence being used. The court itself, the judge herself, can say that, look, the way that this evidence was obtained was in violation of fundamental rights, and if we allow this to be used in this courtroom, it'll bring the administration of justice into disrepute. People will develop a bad opinion about courts if we allow this kind of evidence to be encouraged. And so they'll throw the evidence out even if nobody's objecting to it. Now, why does this happen? Well, it could be because it relates to certain kinds of relationships, an example like an attorney-client relationship that we want to protect. You also have privileged relationships with your doctor, where we say, okay, even if the doctor would be able to tell us some information that could be important to this case, we're going to protect. It's important to protect people's relationships with their doctors. It's important to guarantee people's legal rights by protecting their communications with their attorney, with their lawyer, and say that even if you say something that could hurt your case, if you say it to your attorney, nobody can force your attorney to testify against you in a court of law. Likewise, you can't force a doctor, unless there's very specific exceptions, to testify about privileged information in a courtroom. And even if the attorney wants to testify, attorney-client privilege is so strong that in most cases they'll be prevented from doing so, because that's a privileged relationship. In order to ensure that people really have legal rights, we have to protect that by saying whatever they say to their attorney is a secret. Now, this brings us to the most important rule of evidence, and that's relevance. Relevance is kind of difficult to explain, so let's think of it like this. We already talked about the fact that evidence is all the means by which any alleged fact is established or disproved. That was like the first definition in the beginning of all this. Now, if you look at that from the other side, if evidence is the means by which a fact is proved or disproved, then something that doesn't prove or disprove a fact isn't evidence. If it doesn't establish or disprove a fact central to the case, it cannot be used as evidence, and a lawyer can't bring it into the court if he can't show that it's relevant. So every piece of evidence in quotation marks that you want to bring in front of a court has to meet this gateway criterion that it actually proves something important in the case. It's a fundamental requirement of evidence. It can knock off part of a piece of evidence, or sometimes it'll just mean that some parts of the evidence you want to bring in won't be allowed in. And it's one of the most powerful objections you can raise as a lawyer in a courtroom when somebody's testifying. Especially, like, let's say your client or somebody from your side is being cross-examined. If you object to the relevance of the question that's being asked of your witness, then this can be tactically very, very useful, because it forces the lawyer who's questioning your witness to explain to everybody why their question actually is relevant. And that usually, if they're trying to surprise your witness or sneak around your witness, trick your witness into admitting something that they don't want to admit, then by forcing the lawyer to essentially explain what she's doing, you can really blow up the sneaky attack they're trying to bring to your witness. So objecting to relevance, really strategically an excellent objection.